Environmental law, or environmental and natural resources law, is a collective term describing the network of treaties, statutes, regulations, and common and customary laws addressing the effects of human activity on the natural environment. Regulatory subjects. The broad category of environmental law may be broken down into a number of more specific regulatory subjects. While there is no single agreed-upon taxonomy, the core environmental law regimes address environmental pollution. A related but distinct set of regulatory regimes, now strongly influenced by environmental legal principles, focus on the management of specific natural resources, such as forests, minerals, or fisheries. Other areas, such as environmental impact assessment, may not fit neatly into either category, but are nonetheless important components of environmental law. Impact assessment. Environmental impact assessment is the term used for the assessment of the environmental consequences of a plan, policy, program, or project prior to the decision to move forward with the proposed action. In this context, the term environmental impact assessment is usually used when applied to concrete projects, and the term strategic environmental assessment applies to policies, plans and programs. Environmental assessments may be governed by rules of administrative procedure regarding public participation and documentation of decision-making, and may be subject to judicial review. Air quality. Air quality laws govern the emission of air pollutants into the atmosphere. A specialized subset of air quality laws regulate the quality of air inside buildings. Air quality laws are often designed specifically to protect human health by limiting or eliminating airborne pollutant concentrations. Other initiatives are designed to address broader ecological problems, such as limitations on chemicals that affect the ozone layer, and emissions trading programs to address acid rain or climate change. Regulatory efforts include identifying and categorizing air pollutants, setting limits on acceptable emissions levels, and dictating necessary or appropriate mitigation technologies. Water quality. Water quality laws govern the release of pollutants into water resources, including surface water, groundwater, and stored drinking water. Some water quality laws, such as drinking water regulations, may be designed solely with reference to human health. Many others, including restrictions on the alteration of the chemical, physical, radiological, and biological characteristics of water resources, may also reflect efforts to protect aquatic ecosystems more broadly. Regulatory efforts may include identifying and categorizing water pollutants, dictating acceptable pollutant concentrations in water resources, and limiting pollutant discharges from effluent sources. Regulatory areas include sewage treatment and disposal, industrial and agricultural wastewater management, and control of surface runoff from construction sites and urban environments. Waste management. Waste management laws govern the transport, treatment, storage, and disposal of all manner of waste, including municipal solid waste, hazardous waste, and nuclear waste, among many other types. Waste laws are generally designed to minimize or eliminate the uncontrolled dispersal of waste materials into the environment in a manner that may cause ecological or biological harm, and include laws designed to reduce the generation of waste and promote or mandate waste recycling. Regulatory efforts include identifying and categorizing waste types and mandating transport, treatment, storage, and disposal practices. Contaminant cleanup. Environmental cleanup laws govern the removal of pollution or contaminants from environmental media such as soil, sediment, surface water, or groundwater. Unlike pollution control laws, cleanup laws are designed to respond after the fact to environmental contamination. Regulatory requirements may include rules for emergency response, liability allocation, site assessment, remedial investigation, feasibility studies, remedial action, post-remedial monitoring, and site reuse. Chemical safety. Chemical safety laws govern the use of chemicals in human activities. particularly man-made chemicals in modern industrial applications. As contrasted with media-oriented environmental laws, chemical control laws seek to manage the pollutants themselves. Regulatory efforts include banning specific chemical constituents in consumer products, and regulating pesticides. Water resources laws govern the ownership and use of water resources, including surface water and groundwater. Regulatory areas may include water conservation, use restrictions, and ownership regimes. Mineral resource laws cover several basic topics, including the ownership of the mineral resource and who can work them. Mining is also affected by various regulations regarding the health and safety of miners, as well as the environmental impact of mining. Forestry laws govern activities in designated forest lands, most commonly with respect to forest management and timber harvesting. Ancillary laws may regulate forest land acquisition and prescribed burn practices. Forest management laws generally adopt management policies, such as multiple use and sustained yield, by which public forest resources are to be managed. Governmental agencies are generally responsible for planning and implementing forestry laws on public forest lands, and may be involved in forest inventory, planning, and conservation, and oversight of timber sales. Broader initiatives may seek to slow or reverse deforestation. Wildlife and plants Wildlife laws govern the potential impact of human activity on wild animals, whether directly on individuals or populations, or indirectly via habitat degradation. Similar laws may operate to protect plant species. Such laws may be enacted entirely to protect biodiversity, or as a means for protecting species deemed important for other reasons. Regulatory efforts may include the creation of special conservation statuses, prohibitions on killing, harming, or disturbing protected species. Efforts to induce and support species recovery, establishment of wildlife refuges to support conservation, and prohibitions on trafficking in species or animal parts to combat poaching. Fish and game laws regulate the right to pursue and take or kill certain kinds of fish and wild animal. Such laws may restrict the days to harvest fish or game, the number of animals caught per person, the species harvested, or the weapons or fishing gear used. Such laws may seek to balance dueling needs for preservation and harvest and to manage both environment and populations of fish and game. Game laws can provide a legal structure to collect license fees and other money which is used to fund conservation efforts as well as to obtain harvest information used in wildlife management practice. Important principles. Environmental law has developed in response to emerging awareness of and concern over issues impacting the entire world, while laws have developed piecemeal and for a variety of reasons. Some effort has gone into identifying key concepts and guiding principles common to environmental law as a whole. The principles discussed below are not an exhaustive list and are not universally recognized or accepted. Nonetheless, they represent important principles for the understanding of environmental law around the world. Sustainable development defined by the United Nations Environment Programme as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. Sustainable development may be considered together with the concepts of integration and interdependence. Laws mandating environmental impact assessment and requiring or encouraging development to minimize environmental impacts may be assessed against this principle. The modern concept of sustainable development was a topic of discussion at the 1972 United Nations Conference on the Human Environment, and the driving force behind the 1983 World Commission on Environment and Development. In 1992, the first UN Earth Summit resulted in the Rio Declaration Principle 3, of which reads, "The right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations." Sustainable development has been a core concept of international environmental discussion ever since, including at the World Summit on Sustainable Development, and the United Nations Conference on Sustainable Development. Equity defined by UNEP to include intergenerational equity, the right of future generations to enjoy a fair level of the common patrimony, and intragenerational equity, the right of all people within the current generation to fair access to the current generation's entitlement to the Earth's natural resources. Environmental equity considers the present generation under an obligation to account for a long-term impacts of activities, and to act to sustain the global environment and resource base for future generations. Pollution control and resource management laws may be assessed against this principle. Transboundary responsibility defined in the international law context as an obligation to protect one's own environment, and to prevent damage to neighboring environments. UNEP considers transboundary responsibility at the international level as a potential limitation on the rights of the sovereign state. Laws that act to limit externalities imposed upon human health and the environment may be assessed against this principle. Public participation and transparency identified as essential conditions for accountable governments, industrial concerns, and organizations generally. Public participation and transparency are presented by UNEP as requiring effective protection of the human right to hold and express opinions and to seek, receive and impart ideas, a right of access to appropriate, comprehensible and timely information held by governments and industrial concerns on economic and social policies regarding the sustainable use of natural resources and the protection of the environment, without imposing undue financial burdens upon the applicants and with adequate protection of privacy and business confidentiality, and effective judicial and administrative proceedings. These principles are present in environmental impact assessment laws requiring publication and access to relevant environmental data, and administrative procedure. Precautionary principle. One of the most commonly encountered and controversial principles of environmental law. The Rio Declaration formulated the precautionary principle as follows. In order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. The principle may play a role in any debate over the need for environmental regulation. Prevention. The concept of prevention can perhaps better be considered an overarching aim that gives rise to a multitude of legal mechanisms, including prior assessment of environmental harm, licensing or authorization that set out the conditions for operation and the consequences for violation of the conditions, as well as the adoption of strategies and policies, emission limits and other product or process standards. The use of best available techniques and similar techniques can all be seen as applications of the concept of prevention. Polluter pays principle. The polluter pays principle stands for the idea that the environmental costs of economic activities, including the cost of preventing potential harm, should be internalized rather than imposed upon society at large. All issues related to responsibility for cost for environmental remediation and compliance with pollution control regulations involve this principle. History. Early examples of legal enactments designed to consciously preserve the environment, for its own sake or human enjoyment, are found throughout history. In the common law, the primary protection was found in the law of nuisance, but this only allowed for private actions for damages or injunctions if there was harm to land. Thus smells emanating from pigsties, strict liability against dumping rubbish, or damage from exploding dams. Private enforcement, however, was limited and found to be woefully inadequate to deal with major environmental threats, particularly threats to common resources. During the Great Stink of 1858, The dumping of sewerage into the River Thames began to smell so ghastly in the summer heat that Parliament had to be evacuated. Ironically, the Metropolitan Commission of Sewers Act 1848 had allowed the Metropolitan Commission for Sewers to close cesspits around the city in an attempt to clean up, but this simply led people to pollute the river. In 19 days, Parliament passed a further act to build the London sewerage system. London also suffered from terrible air pollution, and this culminated in the Great Smog of 1952, which in turn triggered its own legislative response, the Clean Air Act 1956. The basic regulatory structure was to set limits on emissions for households and business while an inspectorate would enforce compliance. Notwithstanding early analogues, the concept of environmental law as a separate and distinct body of law is a 20th-century development. The recognition that the natural environment was fragile and in need of special legal protections. The translation of that recognition into legal structures. The development of those structures into a larger body of environmental law, and the strong influence of environmental law on natural resource laws, did not occur until about the 1960s. At that time, numerous influences, including a growing awareness of the unity and fragility of the biosphere, increased public concern over the impact of industrial activity on natural resources and human health, the increasing strength of the regulatory state, and more broadly, the advent and success of environmentalism as a political movement, coalesced to produce a huge new body of law in a relatively short period of time. While the modern history of environmental law is one of continuing controversy, by the end of the 20th century environmental law had been established as a component of the legal landscape in all developed nations of the world, many developing ones, and the larger project of international law. Controversy. Environmental law is a continuing source of controversy. Debates over the necessity, fairness, and cost of environmental regulation are ongoing. Allegations of scientific uncertainty fuel the ongoing debate over greenhouse gas regulation and are a major factor in the debate over whether to ban pesticides. It is very common for regulated industry to argue against environmental regulation on the basis of cost. Difficulties arise, however, in performing cost-benefit analysis of environmental issues. It is difficult to quantify the value of an environmental value such as a healthy ecosystem, clean air, or species diversity. Furthermore, environmental issues may gain an ethical or moral dimension that would discount financial cost. Controversy is not limited to those who oppose environmental regulation. Many groups take the position that current regulations are inadequately protective, and advocate for strengthening regulations.